everyone. Thank you for joining us at our Prestige PEO webinar series. My name is Carrie Kaiser. I'm Marketing Operations Manager at Prestige PEO and your host this morning. Today we'll be discussing sexual harassment complaints and some best practices for navigating those complaints. Joining me today are Liz Shaw, VP of General Counsel, and Colleen Higley, Director of HR and Client Services. Our webinar audience members are muted by default. However, we encourage you to make use of the chat feature to pose any questions you may have. We'll respond to them towards the end of the webinar, time permitting. And if we're unable to get to your question, we'll reach out to you shortly after the webinar concludes. Additionally, the webinar is being recorded and will be made available on our website at prestigepeo.com/webinars for your reference at any time. And now we'll get started with the webinar. Welcome, Colleen and Liz.
Hi, good morning, everyone. It's a pleasure to be here again talking about issues that are really important for employers. Colleen, thank you so much for partnering with me on this presentation today. I'm excited to get into it. Even though it's a serious topic, I think that there's a lot of really good things that employers can be doing to address these kinds of situations and create that kind of healthy work environment that they're looking for. So before we get into all the details today, I'm just going to give a brief disclaimer. As Carrie did mention, I am a licensed attorney. However, the webinar today is not intended to be legal advice. This information is general information for our clients about how they can navigate issues in the workplace and address important employee concerns. So we always encourage our clients, of course, and other attendees to consult with their own legal counsel before they make any actions that might impact their legal rights. So with that being said, and that aside, let's jump into our agenda for today, which Colleen is going to go over for us. So thank you, Colleen. Take it away.
Thanks, Liz. And good morning, everyone. Thanks for joining today. In today's webinar, we'll discuss how to navigate sexual harassment complaints. We'll talk about what sexual harassment is and what a sexual harassment complaint is. We'll review the steps an employer should take to address a complaint in the workplace, an understanding of what can happen if a complaint is ignored or not resolved. And we'll also go over what documentation should be retained along with some best practices for addressing sexual harassment in the workplace.
Thank you, Colleen. So let's dive into it. I think it's always important to lay that foundation for any topic that we're talking about, to just go over some of the high level, really the context in which we're talking about this. So I think most people understand what sexual harassment is, but we're going to do a brief overview of it, and then we're going to get into that content about what to do if you receive something like this. So generally, there are going to be two kinds of sexual harassment that take place in the workplace. The first one is called quid pro quo. This is, in layman's terms, you do for me, I do for you. And when this occurs in the workplace, this type of sexual harassment involves some kind of explicit or implicit demand for a sexual favor in exchange for some employment benefit or to avoid some kind of employment consequence. So a lot of times we would see this in the context of maybe a supervisor saying, in exchange for you, performing a sexual act on me, I will promote you to, this other position. Or, oh, you made this huge error in the workplace. Instead of, firing you for it, how about you do, the sexual favor for me, and we'll just overlook the fact that that happened. That's where we see quid pro quo sexual harassment take place. That's the context. And I think a lot of times people think, well, that doesn't really happen anymore. But I will say, just within the past couple of months, I have had clients reach out who have had issues where some of the allegations involve quid pro quo. So it is something that does still take place, or is at least alleged to still take place. So these types of complaints should always be taken seriously. But the most common type of sexual harassment in the workplace is your hostile work environment. And this type of sexual harassment involves behavior that creates an intimidating, hostile, or offensive working environment. The conduct must create a subjectively and objectively hostile work environment. And generally, at least on the federal level, it's going to involve these elements. It's going to be unwelcome conduct. it is going to be pervasive or severe. So that means that, you know, it's pretty serious, and that it's persistent. So in that context, we are looking for something that is either really, really egregious that has taken place, or something that is happening over time, in at least one or more incidences where, you know, the employer is going to be obligated to address it, and if they know about it, and resolve the issue so that it does not continue to happen in the workplace. So some examples of hostile work environment is unwelcome sexual advances, sexual jokes or comments, um, things like inappropriate pictures or text messages. I will say, with the rise of technology and the use of text messages, more and more in the investigations that we do for sexual harassment complaints, a lot of times those text messages can be quite revealing, and it is often surprising what people are willing to send via text. So that's just a side note for my part. But for our New York clients, I did want to let you know that New York does have a slightly different standard than the federal law when it comes to sexual harassment and hostile work environment. So in New York, sexual harassment does not have to be severe or pervasive to be illegal. The law will consider each instance of sexual harassment uniquely, and look at the facts of that issue. However, the situation itself will still be viewed in terms of a reasonable victim in the same protected characteristics. So it's not like they're just going to necessarily, you know, kind of go just based on what that specific employee felt about whatever happened. It's still going to be, to a certain extent, a reasonable victim standard, versus a reasonable person standard on the federal front. But ultimately, it does create some ambiguity and makes it even more important for our New York clients to take all complaints seriously. And one more nuance on the New York front: if you have remote employees that are working elsewhere who are also making sexual harassment complaints, or maybe engaging in sexual harassment conduct, you're going to want to apply the same standard to them as well. So with that being said, let's talk about a couple of other issues where we see sexual harassment come up. And one of those is gender-based harassment. And just like it sounds, it is based on an individual's gender. So an example of this would be making a derogatory comment about a person's gender, or assuming that they're less capable of doing their job because of their gender. So, you know, for example, this falls into stereotypes like, you know, a doctor is a male, and, you know, a nurse is a female, and acting accordingly, or, you know, making comments about how people, you know, who are women can't be in C-suite positions. Like, things like that would be gender-based sexual harassment. You also want to watch out for your third-party harassment. So this is things that your clients, your customers, or your vendors are doing to your employees. And it does happen where a customer or a vendor will engage in inappropriate conduct towards your employees. And it is your obligation as their employer to address that situation, to make sure that that incident is resolved, it does not happen again, and to protect your employee from any ongoing sexual harassment. That might include terming that relationship with that customer, that client, or that vendor. But again, it's all going to come down to the situation at hand and how it can best be resolved. And then ultimately, I think on a very practical level, things like sexual assault can also be obviously considered sexual harassment in the workplace. And so that would be a non-consensual act or behavior in the workplace, such as groping a co-employee, or, a supervisor touching an employee inappropriately. That obviously is a very serious allegation. There might be some legal consequences on the criminal side for that type of behavior, which would be separate. But as the employer, you still have an obligation to take any of those types of complaints seriously. And there might be some additional steps you might also want to take to assist your employee in what they may need to be able to protect their interests and seek justice for something like that. So, that being said, let's just talk about the context of sexual harassment in the workplace, because by and large, it is still really underreported. According to the EEOC, they say that 75% of people experiencing sexual harassment at work do not report it to their employers. So that puts you at a disadvantage in addressing the situation, obviously. A lot of times, the driving force, though, behind that failure to report is a fear of retaliation for bringing forward a complaint. So the EEOC estimates that only 6 to 13% of sexual harassment victims even bother to file an EEOC charge and seek, that recourse for what has happened in the workplace. But that doesn't mean to say that there aren't sexual harassment complaints that do end up with the EEOC and can end up costing the employer a lot of money. So between 2018 and 2021, the EEOC received over 27,000 sexual harassment specifically complaints. And of these, 78% were women, and notably, almost half of those complaints also included a retaliation component. So that again kind of goes back to what the statistics show in terms of why people don't report it, is that fear of retaliation happening. And we see that accompanied in EEOC charges that are filed, that a lot of them do include additional actions that were taken against them once they brought their concerns to light. So that makes it for kind of a difficult situation for employers to navigate. There is potentially a lot of legal liability out there for employers on the EEOC front. Just with these 27,000 charges, they were able to recover $300 million for the people who filed these charges for sexual harassment in the workplace. But also keep in mind that, this does not take into account things like receiving a demand letter from an attorney who is threatening to go to the EEOC on behalf of their client, and they're demanding, a settlement of some sort in order to resolve the issues. A lot of times that happens, and that also can cost employers a lot of money. So there's a lot of financial impact to employers that can happen. But, statistics aside, one of the things I love most about working in the PEO industry is that I feel like a lot of our clients who come on board with us really want to do the right things by their employees and follow the right practices and procedures. And so really the ultimate goal in addressing these sexual harassment complaints that might happen in the workplace is so that you can create a healthy, respectful work environment where employees can focus on their work, they can thrive, and where they also feel empowered to bring forward concerns, knowing that their employer is going to take it seriously and that they're not going to face any retaliation for bringing forward those concerns. And so all of us can play a part in helping create those environments at our own workplaces for our employees. And, just on a side note, like at this point in my career, I've, encountered some things, from time to time that could be characterized as sexual harassment. And it is an awkward position for the employee to be in and to know how to proceed. And, even knowing everything that I know about my rights and obligations and such, there certainly is that fear that should something come forward, that it will be mishandled. And so our goal today is to help you to not make those mistakes, and so that your employees can feel like they can come to you and you know what to do in these circumstances. So with that being said, Colleen, let's talk about what is a sexual harassment complaint.
Sure. A sexual harassment complaint is an allegation made by an employee or another person regarding inappropriate sexual behavior in the workplace. Complaints can be made in writing or verbally and can be brought by the employee who is experiencing the alleged harassment or by a coworker who witnessed or may have heard about it. It can also be brought through a third-party agency, such as the EEOC, for example. A complaint will generally include the date of the incident and where it happened, the nature of the behavior, the names of individuals involved and any potential witnesses, and it will describe the impact it has on the employee and the workplace.
So this is generally some things that you're going to want to have on hand if you receive a harassment complaint, so that you can then take some action to address the issues. It's always important to know what you're dealing with when you get a complaint. So what steps should an employer take if they have received a complaint of harassment in the workplace. And ultimately, I know there's a lot of information on the slide, but focus on the bold stuff as I walk through it. But first and foremost, take the sexual harassment complaint seriously. That's step number one. Don't blow them off. Do not push it aside and not deal with it. It is a situation that you need to really sit down, take seriously, make it a priority to address it. And at this point, when the complaint is brought, it's not at that point that you're going to be deciding whether or not this incident has any merit or actually happened. It's your job to investigate the complaint. So what are you going to do? Sexual harassment complaints can be really sensitive topics for the employee who experienced it to talk about, for others who may have witnessed it to feel comfortable describing what they may have seen. And it really can be a sensitive subject. So Prestige is here to help our clients navigate these types of complaints. So if you get a sexual harassment complaint and you need assistance investigating the complaint, we are here to help. So reach out to your HRBP or your HR consultant for assistance in investigating the complaint. You do not have to handle this matter on your own. We're here to help. But you also can do some other things. You don't have to necessarily use us, although, this is some of the things that we do on a daily basis as we look into these types of things. But you can also have a member of your internal HR department look into it. You can have a member of management look into it, or you can use another third party to investigate the matter. But the most important takeaway is that an investigation does need to be conducted. So whoever is conducting the investigation needs to speak with the person complaining of the sexual harassment. So the goal in that is to obtain as much information possible as you can get about what happened, who was there, when did it happen, what exactly was said or done, what was the context in which it happened. The more information that you have, the better you'll be able to navigate the investigation and really ultimately be able to come to a conclusion about what has actually happened. So you're going to let them know that you're taking their complaint seriously and will be looking into the matter. And that you'll follow up with them at the end of it. That will be an important step in the process. So from there, you're also going to want to evaluate whether or not the person who has been accused of sexual harassment needs to be separated from the person complaining of the sexual harassment while this investigation is being conducted. There are plenty of times when people work in very small quarters together, or maybe on the same shift or in the same office, where there is a potential that there's a risk that the sexual harassment might continue, or the person who's complaining is afraid to be around the person who harassed them. And at that point, the goal is to, at least for a brief period of time while you investigate, to potentially separate those individuals. I mean, you're going to want to look at the context in which the complaint has happened, what has taken place, how the person who's complaining is feeling about the situation. But ultimately, if you can, maybe change the accused schedule or have them work from home for a few days, like sometimes that's best just to create that distance so that nothing further occurs while you're looking into the issue. So the next step that you're going to want to do is you're going to want to speak with the witnesses. Now, it's possible that a whole bunch of people witnessed what happened, and you don't necessarily need to talk to all of them. When you're talking to witnesses, you are putting them in a protected category where you are giving them this protection where they're involved in this investigation, so you need to make sure that you don't retaliate against them for being willing to participate in this situation and share what they know of it. But it's possible, like let's say 10 people witnessed it, but when you talked to the person complaining, they identified that these three individuals were the closest, they heard the most. Those are likely the people that you're going to want to talk to, the ones that have the most information. And so what you're going to want to ultimately be able to establish by talking to witnesses is whether or not the incident happened. And that's what we call whether or not you can substantiate that the allegations of what took place actually took place. So that's an important part of the process. Sometimes there's not any witnesses. And at that point, it is what it is. You can't necessarily control the circumstances that you're looking into. So you may not have any witnesses to follow up with. But that doesn't mean that there isn't additional steps that you can take to still investigate what is happening. So the next part of the process, after you talk to the witnesses, is to talk to the person who's accused. So, look, ultimately, an investigation is not a legal proceeding. It's an internal employment matter. So it's not like the accused necessarily has rights, necessarily. However, you do still want to give them an opportunity to respond to the complaints, and to be able to share their side of things. And I think this is important because a lot of times people feel like they didn't have an opportunity to share their side of things. They walk away from whatever the outcome is of the investigation, angry, not feeling heard, and potentially bringing their own claims against the company. So speaking with the accused gives them an opportunity to share their side of the story, to deny the allegations. Sometimes they admit the allegations, sometimes they say, yeah, this happened, but here's the context in which it happened. And, that might provide some additional color, so that you have a good context for what has occurred. But that's a really important part of the investigative process into a complaint. And then at the end of your investigation, you need to decide if corrective action is needed. So there are a variety of things and tools that you can use to address a sexual harassment complaint once it's happened. And so some of the things that you're going to want to evaluate is whether, based on the outcome, is a verbal warning warranted in the situation? Is a written warning warranted? Would a policy reminder be sufficient to address what happened? Or is something more serious, like a suspension or a termination, an appropriate course of action? So when I say things like policy reminders, I personally, from an HR standpoint, I love policy reminders. I think they're a great tool to use. So let's say you have a sexual harassment complaint where the person said maybe one slightly inappropriate sexual, joke in the workplace. Someone complained. Overall, the employee is, a good employee. They haven't received other complaints. It's possible that giving them a verbal warning and then what's called a policy reminder would be sufficient to address what has happened in the workplace. So a policy reminder is something that you can also give to other employees as well. And what it is it outlines, this is what the company's policy is about sexual harassment in the workplace. These are the behaviors that, while not all inclusive, are things that we expect you not to be doing in the workplace. And as a reminder, any violations of our policies can lead to disciplinary action up to and including termination. So a policy reminder isn't disciplinary action, but it is a reminder and something that you can show that you used to address a situation in the workplace. It can also be used if the allegations are ultimately unsubstantiated, so you don't know whether or not it actually happened. Sometimes giving a policy reminder to that individual who was accused or to the whole company is a good idea, just so that everybody knows what the expectations are for behavior in the workplace. So once you've identified the corrective action that you need to be taking, at this point, you need to take it. And sometimes employers avoid this part because it is hard. It's hard to, discipline someone. It's hard to terminate people. Those things are not easy. They're probably some of the hardest parts of being a manager or a supervisor, is actually following through with it. But this is an essential part of the investigation, is to actually take the corrective action that you've identified as needed. And then at the end of your investigation, you want to follow back up with the complainant. Let them know that you fully investigated the allegations that they brought, and that the company has addressed the matter. What this doesn't mean is that you have to tell them exactly what the company ended up doing to, um, to address the situation. So for example, let's say you had a sexual harassment investigation and it was very clear that the person engaged in the conduct they were accused of, and you guys decided, we need to terminate this person. What you can do is when you're talking to the person who complained, you can say, hey, we've conducted our investigation. The company has taken, proactive, measures to rectify it. If you have any further issues, let us know. You do not have to tell them, oh, and we terminated the person. They're going to figure that out on their own when the person doesn't show up for work next week. So again, that's kind of keeping the employee's own disciplinary actions siloed and applicable to that particular employee without necessarily bringing in that information to people who don't necessarily need to know that. The person who is a complainant, they just need to know that you took their complaint seriously, you've investigated it, and you've addressed it. So that was a lot of information about moving through that investigative process, and it is a process and one that should happen quickly. But once you've done, your investigation, what kind of documentation should the employer retain, Colleen?
Sure. So it's important for employers to retain documentation so that you have a record of the complaint that was made. It should include the date of the alleged incident, the complainant's name, names of any witnesses, and the name of the accused, whether the allegations were substantiated or not, and what action the company took to address the allegations, and documentation of any disciplinary action taken, including any training or policies reminders that were given. I would also like to note that Colorado has passed detailed legislation requiring that employers keep detailed records of harassment complaints. So Colorado employers may have additional requirements to comply with as well.
Right. And yes, this is so crucial to have that paper trail, really, of what you guys did to address these types of issues. Okay, so at this point, Colleen, let's move on to the next part where we talk about what employers can be doing to protect themselves from these types of situations.
Sure. Thanks, Liz. Employers should have a strong handbook policy regarding sexual harassment in the workplace. That's very important. Prevention is the best tool for eliminating sexual harassment, and training is an important step to aid in the prevention. There are several states that require employers to provide their employees with sexual harassment training, but it's recommended to train all employees, even in states where it's not mandated. Training helps employees understand how to recognize, help prevent, and how to report sexual harassment. It not only educates employees and raises awareness, but it helps to create a respectful workplace culture. Some other best practices are consistent discipline and documentation, investigating all complaints that are received, and driving employee engagement and a respectful workplace culture.
Right. And doing these things provides so many tools and so many layers of protection for you as a business against claims and potential EEOC charges, lawsuits, and also obviously to provide that environment that you want to create for your employees. So at this point, we're going to go through each of these things that we're recommending that you have in place and that you know how to do. And we're also going to go through some examples of some not real life examples, I made them up, but some examples of what I've seen happen and some reasons why having these things in place can really be helpful to the employers. So Colleen, you want to take it away with employee handbooks?
Yes, so there's a few important handbook policies that employers should have. First, an Equal Employment Opportunity or EEO policy. It outlines an organization's protection and equal opportunities for protected classes under both federal and state law. It memorializes the company's commitment to fair treatment of employees, and it provides a process for reporting allegations of harassment in the workplace. And secondly, a sexual harassment policy that outlines appropriate and inappropriate conduct in the workplace. And it should also provide for a process for reporting allegations of sexual harassment. And a well-designed handbook sets an organization up for success. In the event of a complaint, the employer can show that they take all complaints seriously, that they have an established process for addressing these concerns in the workplace, and that any legitimate action against an employee, such as a termination, was appropriate under the company's policy and did not violate the law. It's recommended to also have a signed handbook acknowledgement showing that all employees received the handbook and that they're aware of the company's policies.
Right. And if you're a client of Prestige, you probably do already have an employee handbook. If you don't, we have them. We can help you put them together, and they have these really important policies in there for you. All right, you want to do the example, Colleen?
Sure, I'll share an example. Sam started with the company on September 15th, 2023, and she received the company's handbook during her orientation, which explained the company's process for handling harassment complaints. From the beginning of her employment, Sam's coworker Michael would make sexual jokes at Sam's expense in front of other employees. Sam complained to her supervisor Joshua about Michael's comments. The company spoke with Sam, and the witnesses Sam identified confirmed that Michael made those inappropriate sexual jokes about Sam, but Michael denied the allegations. The company ultimately terminated Michael for misconduct and breach of the company's policies. So the company's handbook has served several important purposes here. It shows that they have established a strong policy against harassment in the workplace. Sam knew who she needed to talk to contact about her concerns. And Sam's supervisor, Joshua, knew what he needed to do to respond to the complaint. And Sam's complaint was appropriately investigated and corrective action was taken.
Right. Thank you, Colleen. So now let's move on to consistent discipline and documentation. I think personally this is one of the hardest ones because, as an employer, it really stinks to have to be the quote unquote bad guy addressing issues in the workplace. But the more consistent you are and the more fairly you treat your employees in enforcing your policies, the more you're going to be setting your company up for success. So when you do consistent discipline and documentation, you are setting expectations for workplace behavior. So you have your handbook policies that set forth those expectations, and then you have the actual follow through of the company holding people to those expectations. Oftentimes, discipline will be progressive, although in the context of sexual harassment, there may be an issue that's so egregious that it requires immediate termination. So you might not see that progressive discipline in the context of a sexual harassment complaint, but generally, discipline and documentation is going to be progressive. You want to keep any kind of policy reminders, write-ups, or termination forms in the employee's file. That is so that in the event you ever have to produce them, you have them there, it's organized, and you have that proof to show that you did what you were supposed to do. And then it's often recommended, and I think it's always a good idea, to have an internal witness to the discipline. So, for example, if someone were to, violate the company's policies, Colleen may be the one who is disciplining the person, and I may be there as a witness just to see, their response to, the discipline, in the event they refuse to sign any kind of disciplinary document, I can sign that I witness that they were provided that documentation. And it's just always good to have, those two people who were in the room who observed the same response from the person who was being disciplined. It's just, I think, a good fail-safe and a good support system for the person who is having to do the disciplining. So, it's not an easy thing to have to do. So let's talk about another example of discipline and documentation. And some of my examples are a little close together in terms of names of people, but they do vary. So here we go. So Sam started with the company on September 15, 2023. So she receives the handbook at orientation, lets her know how she's supposed to report sexual harassment complaints. And again, from the beginning, her coworker makes sexual jokes at Sam's expense in front of other employees, according to Sam. So Sam complains to her supervisor, Joshua, about Michael's comments. The company investigates the complaints, but they ultimately find that they could only substantiate that he made one inappropriate joke to Sam. So at that point, the company decided to issue Michael a verbal warning, make him do some sexual harassment training, and they also gave him a policy reminder. And so at that point, they've addressed the situation, with Sam and Michael, and that is resolved. However, a couple of months later, the company receives another complaint against Michael from another female employee. And after investigating that complaint and substantiating that, yeah, he did what he was accused of doing, the company decided to move forward with termination. So, by doing consistent discipline and documentation in this case, it has served several important purposes. So again, you have the company has established a strong policy for against sexual harassment in the workplace. It shows that the company then enforced their policies and how they navigate these situations, and it establishes the record of the steps that they took to address the complaints. So that is where this consistent discipline and documentation and records really come into play and are really good tools to have. All right, so another thing that is really key is employee training. And a lot of states and some localities mandate sexual harassment training. So, for example, New York and Illinois both have their own harassment training requirements when an employee starts and on an annual basis. I know this month I still need to do my company's annual sexual harassment training. It's on my list of things to do. And it's just something that is mandated by that state, and that, there are specific requirements there that have to be met for what is included in the trainings. Other localities like Chicago and New York City have their own training requirements. So if you're in those areas, you want to make sure that whatever you're pushing out is compliant with those localities as well. California, for example, has a training requirement that the training be interactive with the employees, and that documentation of that training be kept for a minimum of 2 years. So different states and localities have different expectations for it, but not every state requires sexual harassment training. But the ones that do often have specific deadlines and content requirements. So that's something to keep in mind. And just know that as your PEO partner, for our clients, we do have resources for trainings in these localities that, we can, assist you with so that you can remain compliant with those requirements. However, there's some other important trainings that I think are really beneficial. So if you're in a state or locality that doesn't require sexual harassment training for your employees, you're still going to want to get them sexual harassment training. It's a good thing to do. We have various tools at our disposal that we can share with you so that, all of your employees are on the same page about what the process is, what the expectations are, and they get that training hopefully on an annual basis. But additionally, I think there's some really important trainings for supervisors that are going to help empower them to do those enforcements and do those things that they need to be doing as a supervisor to address issues in the workplace. So I think harassment and discrimination training for supervisors, where you're really focusing on how to handle those issues in the workplace, is a good thing to do. And discipline and documentation training, I think, is a really good thing to do for your supervisors, because sometimes it's just difficult to know, what do I write in the write up? What do I write on the termination form? Like, how do I decide what's an appropriate disciplinary action in a specific context? And we're here to help with that as well. We answer questions about that type of stuff all the time. We're certainly willing to talk through it, but training is just another way to empower your supervisors to know what to do. And then you always want to keep a log of whoever is attending the trainings, and it's strongly recommended that the employees sign off on attending the trainings, acknowledge that they've done it, and that's just a good thing to keep in your files should anything come up down the road as well. Okay, so let's do an example of employee training and how it can help the company. So Dylan was hired in April of 2023. He completed the company's mandatory sexual harassment training during his orientation. But from the beginning of his employment, he just refuses to do his job. He refuses to attend meetings. He's not an ideal employee. So after dealing with this for a few months, the company says, you know what? by October, we've had enough of you, Dylan. We're going to terminate. And so they do. Unfortunately, Dylan then goes and files an EEOC charge, and in his charge, he alleges that he complained of sexual harassment in the workplace and then was fired due to his complaint. But Dylan never made a sexual harassment complaint to anyone at the company before his termination. So they were completely caught off guard, weren't expecting this because it just didn't happen. So what having an employee training that Dylan had to do will help the company is in their response to Dylan's EEOC charge, the employer can use his attendance at the training to show that they take sexual harassment complaints seriously, that he was trained on how to report, sexual harassment and what the company's procedures were for that. And while they will still need to argue that Dylan did not make a complaint of sexual harassment, they can still show that they take harassment complaints seriously and that they make sure all their employees know the expectations in the workplace. So that's, again, another level of protection for the company. Okay, so let's talk about investigating complaints. So we did go over this earlier, but I think it's a good idea to just go over it one more time. That if an employee brings a complaint of harassment, just a reminder, you do have a duty to investigate that complaint, and you have a duty to do so quickly, okay? Even if you think the complaint does not have merit, take it seriously, investigate it, resolve it, and hopefully be able to move forward. So if you receive a complaint, we can help with that. Report the complaint to us. If you would like, we can help investigate the allegations and speak to witnesses who may have also observed the situation. And then we're happy to offer you practical advice on how you can address the allegations and help you identify any corrective action that you may need to take given the circumstances. And then also, as a reminder, you should advise the complainant that you've investigated their allegations and you've taken that corrective action. And again, they don't need to know the details of exactly what it is that you did in most states. However, they should know that you took their concerns seriously and that you did not ignore them. So let's do an example of investigating a complaint. So Sam started with the company in September of 2023. Again, she receives the company handbook. She knows the company's process for investigating sexual harassment complaints. And from the beginning of her employment, this coworker, Michael, would make sexual jokes at her expense in front of other employees. So Sam, again, complains to her supervisor, Joshua, about Michael's comments. The company speaks with Sam. They speak with the witnesses identified by Sam, and they ultimately talk to Michael, who says, I didn't do that. I didn't say anything inappropriate. So he denies everything. And so the company takes a look at the totality of their investigation, and they ultimately decide to terminate Michael for misconduct and for breach of the company's policies. So Sam's employer's investigation has served several important purposes. It shows they took the complaint seriously. It shows they had an established process for investigating complaints, and it shows that the company took that appropriate corrective action based on the outcome of the investigation. Investigations can be difficult to navigate, especially in a timely manner. I mean, we're all pretty busy with other things, but it's important that they are a priority for employers. All right, Colleen, talk to us about employee engagement and workplace culture and how important that is.
Sure. So I'm going to discuss retaliation. Even if a claim has no merit, it's important for the complainant to be treated respectfully and the same as all other employees. It's easy for employees to show retaliation because it's human nature to feel wronged by a complaint made by someone or to react in a negative way in response to it. Sometimes problem employees are the ones making complaints that may or may not have any merit, but all allegations should always be investigated. A company with a healthy workplace culture and willing to engage with employees about their concerns reduces the potential for the company to get an EPLI claim or a lawsuit. It's important for employees to feel comfortable bringing forward complaints. The company should have an open door policy, and a respectful workplace culture is key. Managers and supervisors should always treat all employees with respect, and behavior starts at the top. All upper management should be held to the highest standards and serve as role models in the organization. And now I'll share an example.
Our last one. Let's go.
Yes, this is a long one. Judy and Christina are hired as receptionists on January 15th, 2023. Judy works at the company's Melville office and Christina works at the company's Garden City location. They're both terrible at their jobs. And in June 2023, the regional manager, Anthony, sexually harasses both employees. Judy and Christina complain to their supervisors about the behavior. The complaints are investigated and Anthony is terminated. Judy's supervisor is annoyed that she has more work now, though, that Anthony is gone, and starts making snide comments to Judy about the situation. Christina's supervisor is very supportive of Christina and continues to treat her the same way. Both Judy and Christina continue to be terrible at their jobs, though, and by the end of September 2023, both employees are terminated for poor performance. Christina accepts that she was terminated due to her performance, and since she felt she was treated fairly by her supervisor, she doesn't file a claim. However, Judy's hurt and embarrassed by her supervisor's poor treatment of Judy, so she decides to file a complaint with the EEOC for retaliation. The company is going to argue that they terminated Judy due to a legitimate, non-discriminatory reason. However, Judy's supervisor has now exposed the company to this retaliation claim because she treated her differently than she did before the complaint.
Right. So how you treat people is just so crucial. Creating that open door environment where they can bring forward their complaints, taking them seriously, and then after the dust has settled, to make sure that you are treating people with fairness and respect. It's so important. And I think, a lot of times, from my perspective, when we're getting complaints from employees, that not necessarily sexual harassment complaints, but other complaints, a lot of it comes down to how their supervisor or their management team is making them feel. And that's why it is so important to create an environment where people feel respected and treated well, so that if something like this occurs, the company has already established a good rapport with the employee, a respect that is felt by all of their employees, and that can really help mitigate any additional liability that the company could face. Because at the end of the day, unfortunately, you can't control everybody's behavior. And there are going to be situations that sometimes arise in the workplace that have to be dealt with and can sometimes be pretty messy. So, what can happen though if a sexual harassment complaint is ignored or is not resolved? And this is our last topic that we're going to talk about today before we take some questions. But ultimately, there's a couple of risks if you just decide, I'm not going to deal with the problem. And so the first risk is that the employee may continue to face sexual harassment, or the harassment may escalate in the workplace. And that can lead to emotional distress for the employee, increased work-related stress, decreased work performance. And then it also just sends that really poor message about expected behavior in the workplace. So ultimately, your employees' welfare should be a top priority for you, which is why these things should not be ignored. Even if it's an employee that you don't like, they're a pain in the butt, they're always complaining about something, it's really just important to make sure that you take it seriously and look into it. Additionally, someone who has complained may exercise their legal rights to file an EEOC charge. And ultimately, the company may additionally face potential litigation down the road based on a sexual harassment situation that maybe was ignored or not addressed. And then if that happens, the company is not going to have any kind of documentation to show that they took it seriously and that they addressed it. Even if the result is not what the complainant wanted to happen, they can at least show that they did their part and that they did take corrective action. And so that's just a really important thing to have at your disposal as an employer. And then there's always the risk that the person accused of sexual harassment may harass additional employees. And that again increases the risk for exposure for the company in the workplace. And it continues to expose other employees to unacceptable behavior in the workplace. So, all things we don't want to happen. It's just better to address it and be able to hopefully move forward and get it resolved. So, Colleen, what can we do to help our clients as they navigate these issues?
Sure. So we're here to help. As a Prestige client, you have access to our federal handbook with state addenda. If your company does not have a handbook in place, your HR business partner can assist with that. And every client has a dedicated HR business partner to help provide HR guidance for issues in the workplace. And our HR consultants can assist with sexual harassment complaints if you receive one. Our LMS platform has a variety of trainings available. You can reach out to your HR business partner for more information on that. And lastly, we have compliance updates as well as other resources available for managers on our website.
Right. We are here to partner with you to help you navigate these things. Take advantage of the resources available to you. We're always here and ready to dive into these difficult things. So at this point, I think I'm going to turn it back over to Carrie with any questions that we received that we might be able to answer.
All right. Thank you so much. We really appreciate you taking the time out today, Liz and Colleen. We did have a few questions that came through our chat. We'll address a few of them now, and then if we don't get to your question, we will reach out to you privately to discuss. The first one here is, if I get a complaint from an employee, who should I reach out to first at Prestige?
That's a great question. So your HRBP is going to be the best person for you to reach out to initially. If you all also already work with one of our HR consultants, you're welcome to reach out to that person as well. I think going to your payroll specialist or benefits specialist is just going to kind of delay getting the information to the right person. So definitely your HRBP is going to be your first line of defense, and our HR consultants are here to assist in really helping dive into what exactly is happening.
Okay, great. Another question, let's say one employee complains about another employee and both employees have violated our policies and procedures. What do we do then? And are we at risk for retaliation claim if we term them both?
So that's a good question. And honestly, that's a tough one. I think a lot of it's going to come down to the specifics of that situation. What I will say is I have seen plenty of situations where you have two employees who are just engaging in behaviors that they just shouldn't, and one then complains about the other. And at that point, as you're doing your investigation, you're finding out that they're both doing just all sorts of things they shouldn't be doing. And it might be a situation where it is appropriate to terminate both of them. Is there a risk for a retaliation claim? Yes, there is. I think there certainly can be. But that's why doing that, doing the investigation, doing your due diligence on discipline and documentation is so important. So that you can establish that you had a legitimate, non-discriminatory reason for terminating that employee, if that's what it comes to. But what I would also say is, move cautiously. Those types of situations can be very messy, and you might want to involve your legal counsel in talking about the risks before you move forward with terminating the person who brought the complaint, because there is um, that time between when they complained and when they're terminated that they can use to show that, oh, this was based on, retaliation, not based on all these other bad acts that I also engaged in. So there's always risks that are there, and it's definitely good to evaluate those risks and also evaluate ways that you can mitigate the risks while still addressing issues in the workplace.
Okay, great. And the last question we'll take today is, what do we do if the person who has done the sexual harassing is a key person to our organization? And how do we navigate addressing the complaint and dealing with the fallout of the investigation?
Yeah, I mean that's a tough one. Sometimes the harassment comes from the top, and that person is integral to your organization. I think on in those situations, it's important to still stay true to your organization's standards and policies for behavior. Um, but I think the logistics of navigating how to address it is going to be important. So again, using a third party to look into the allegations and to investigate, and then to report back potentially to the company's board instead of, maybe the CEO who's been accused, or, something like that, may be the way to go to really address the issue. Additionally, it might be a situation where you want to, get your legal counsel involved early to be able to help you navigate that, especially if the person has employment contracts or other, just more complicated and integral parts of the business. And there obviously has to be a transition plan in place if you do end up parting with that key employee so that the organization can continue to move forward in their absence. And so those ones, are difficult ones. They're complicated. Hopefully you don't have to deal with those types of situations, but if you do, just know your obligations as a company are the same in terms of taking the complaint seriously, investigating it, and taking corrective action. And it just does get pretty complicated pretty quickly. So those are certainly situations where you want to be talking to your employment attorney, definitely be, reaching out to us, for our assistance as well, so that we can, help you navigate, that type of a situation.
Okay, great. I think we did have a few more, Liz and Colleen, but I think we'll stop here and we can reach out if we didn't get to your question shortly later today. But thank you again to Liz and Colleen for this helpful presentation, and to everyone who joined us today. The recording of this webinar will be available on our website. Just give us about 24 hours at prestigepeo.com/webinars. If you have any further questions, feel free to contact your Human Resource Business Partner for further assistance. And don't forget to check your inbox for our monthly Insights newsletter, delivering the latest HR news. Thank you all, and we look forward to seeing you next time.